say can Agyapong you buano attain and I buano attain.
Okay, I think the kind of I don't know if you Chigana for if you say you say yeah tomwa we semno ya kofi semno sa sense for you find me no first to attain the kind of way out to more for no for that say no for Ghana and she say you the first to attain no what and I say obefa aboafo I from jury now for so above the Nelson say you so jury na with more for one and matches on chair or acquire or more faso efficiency in this the evidence between animal quite no more faso by checking be much and remembering I also also with the court I can dream now for your man show to say and there's more from that show Omundi Subiano and also with this of Pepe. It was more from the US idea will be now. As some of Anas issue US court no, only use jury system no, and no more from the match of the movie now a more casa more I know what their court no, the verdict no, and no the more from the Hoshe now almost and no more the back. And so it's important to say the kisa distinction now say you in the decision by man and verdict bar and yet conclusive enough. So jury no econo for ginger and no ban you and some are caught in the my say I against someone in safety. I guess a court no fast assembly now Bonibeka say or internal as a decision or a judgment of the court. Court may fight a kind of adoption. Also, court may just assembly. No court man can say it seems so. Say we in a year Moya court at the Bible thing. In such matters, the court necessarily has to take the verdict and enter it as a decision of the court or a judgment of the court. Anything short of this, via every judgment. It said. To pay attention to some of the arguments I know on social media. What is that from Sakoko side? The post of against a lot of conversation. He was very specific, saying the jury in the SS court has awarded a verdict of 18 million against Kennedy Agyapong. One can say the court has awarded a judgment of. In some sense, I think that those distinctions are key. And there he has said, there is no judgment against the Agyapong. Legally speaking, there is no judgment against him. Now, the US laws no say, yeah, what these damages against you, are both say, what can do this or can not, they can say, could change to be poor. There is this legal principle I find remedy so. And what you say, your both have a quarter, and man of my point says, we did this as I can, a bullet soon far. Who cannot catch it? Court say the idea to me so idiot. I say no solution of a taboo I can soon the where the mother will do on such a moment. Court meet me actually no one should share and say no shine. The entire my US for this principle never any said say who your case in the normal system where you have a judge sitting on the case. He is guided by the rules of law, the facts and all legal principles. But in a jury system, the jurors are not necessarily making their decision based on the rules of law or the specific provisions of law. For example, say if they are judge or making an award against your bishop that makes act, or they make specific awards, for example, if they are for the road traffic offense, causing harm to other road users and everything, and running saying a 20,000 penalty and a 100 penalty unit. Penalty that could be a 12 cities. So he will multiply that by that. But a jury can make some decisions no matter how outrageous they are. And I didn't say the whole jury system is built around the perception that jurors may afford they represent the larger society. into their feelings are that of the larger society. And sometimes they may go overboard kakra. So for example, only judges begin come, I don't tell you. There was this case, I think it happened in Ashanti region. And we are forming and about a kubako. So it's another case. First, we need another case. Now, judge no every jury now call you the expectation is that they will come up with a guilty verdict. But the star witness in the case is Mammy the mountain son. And somehow or catch a jury they say, we say about time, we bay or condemn when in the shame. It is not that the boy has not committed murder, but the woman is appealing to the emotions of the jurors. And jury system, we say, oh dear, you know how to appeal to the emotions of jurors. Oftentimes, you can have a decision going your way. It's my now, the Baba Kun, the Kofi Ahon and the customer. If it's a matter before a judge will decide, the judge will go strictly according to what the law says. Section 29, Section 30, and then Omokafa Medaho, and sentence again, life imprisonment, death sentence, whatever it is. That is what the judge will do. But a jury has to now come up and say the person is guilty or not guilty. Or someone is either declared judge is who should be. And they are not making that decision necessarily on rules of law. At best, they will do so based on the facts available. If we are not a jury system, sometimes, example, the U.S. court, any journalist who goes to a U.S. court for defamation is likely to win, dependent on the kind of arguments that the person makes. If the arguments Anas made in the U.S. court he created the impression that in Ghana, some people are above the law, especially politicians. This is a statement that will appeal to every single juror in the United States or any part of the Western world, whether it is true or not. What's the mechanism? Because I mean, we're all here when even President Trump was held before legal processes and all of that. So before a jury, you have the chance to. You can even be manipulated and get away with it. Jurors are sentimental. It is all profile jurors who say, "Oh, we have neighbor, we Christian, we say." You know how to play with your arguments to get them to give you the kind of.
But George, and no dear, more na more yellow ejuma. Obviously, some quarter. You can't so be making an argument, but superior arguments in the beginning. I'm sure, sir. Agyapong Nankasa, it's me the necessity in the book and said, me, Busika, I'm going to pick the best lawyers, underline best lawyers. I'm very sure, sir, the best lawyers now, Agyapong Jew Mudino. Omunim, all those things say they are during the say it. So one was in here, because honestly, I'm saying this because the ama excitement in Nabano may not be necessary because of Agyapong, but there are excitement me be a quiet to say anke Ghana ha kebe frustrated system na ma wan hwe nkana se nipa no kwa odi bi ma na odi fo a na ko problem. And a case study could be yemfa say you can JB Dankwa MP. Look how many years in ye yentimi nyai, but they be an enke ya brochira keti na so ben say odi fo na say odi bem obi betime de na sama kokko to ha me a frustrating na ye nyina ya victim pay ye be frustrating na fe no is it not something that at least your court system no, we need to work on that?
No, I think that comparison is a wrong one. First and foremost, in fact a jury case and compare a street case where it is an indictment proceeding. A wrong comparison. The motives are very, very different. I have to say, will be a percent of compare a radio show host by his ability to write. It's not necessarily the same. Now, the kind of And the example you made, the JB Danko example, let's even stick with that example. It is a murder case. Doing a murder case in Ghana, doing a murder case in US, there are things that would help you. But generally, there are some principles that would guide you. Every murder case, there are two ways of assessing evidence. There is what we call the preponderance of probability and a balance of probability. So, you are putting things together to suggest that there is a likelihood something happened, or there is a likelihood that something did not happen. You can say, oh, we did say a day, by, and answer. But you are quite able to say murder. It comes under what you call proof beyond reasonable doubt. And also, it's share evidence, so you cannot compare these two situations. Now, you get back to even the jury process. Now, I mentioned earlier, say the judge or the court instructs the jury on exactly what to do. If the jury in any way deviates from that specific instruction, it becomes a ground for mistrial, which is one of the contending issues before the court now. Now, court, Emma, jury, and a human answer, say, first and foremost, the jury was supposed to decide, say, in Agyapong, are you guilty and are you guilty of the issues that have been brought before the court. Now, the second thing the jury was supposed to do is say, so one will say, are you guilty? Yeah. Then we should assess actual damage. Actual damages are in Germany. Beyond that, you should also assess defamatory damages. Now, no one is away in a court with the man with on yet. The court set a different date. So Baba Bishia to come and assess what we call punitive damages. Punitive damages means say assessment, was it of an aggravated nature? Maybe an abroad so Nipano or they could do the benefit or they could do an abibisa. Court, a bar. That's a case of punitive damages. The jury now, so the court asked the jury, says, on this you are to assess punitive damages. The jury now says that, oh, you don't see any, now on the Friday, last Friday, he has assessed actual damages at $5 million, compensatory damage at $5 million, and punitive damages at $8 million. Meaning, I want about 18 million. And then, the defense counsel, Agyapong, raised the issue that this is grounds for mistrial because instructional court made the jury, it appears that Omojima is now, if you listen to the video now circulating now, the judge in acknowledging the verdict of the jury indicated that he was going to, and before that he had mentioned that he will not take oral submission for mistrial. He will take oral submission. If you are the one if you also are, when the judge feels that the matters are weightier, a better choice to come on the record. You have to come with a written submission or written motion. The judge told them, say, on the issue of mistrial, he was not going to entertain an oral submission. So the parties should come with a written submission. And then Agyapong's lawyers have taken steps to file the written submission. Now, when that is done, court will 30 days to determine the issue of mistrial. Two things are going to happen.
Religion.